For today's United States Supreme Court case, we turn our attention to when a co-defendant's confession can be used against you as it relates to the confrontation clause. So, as will surprise absolutely no one, many crimes are committed by multiple different people, potentially involved in a conspiracy with one another. And the multiple different people are brought to prison and brought to trial and brought to all the bearers that will have the law enforcement after them. But what if one of the people cops a deal, right? One of them cops a deal and confesses to the crime, right? Says, yes, I did it. It was me. I did it. I was part of the conspiracy. I want to go to prison now, please, very, very much. All right. So this person has confessed. They've confessed to their own responsibility, but they've also confessed in a way that implicates someone else, right? They're part of a conspiracy. So they are saying someone else is also guilty by necessity. So the question is, how can we use this confession, the allocution in open court, mind you, how can we use this, if at all, in the trial of another person? Can we use this confession against the other person? Or do we have to present some other thing because of the confrontation clause? What is required when it comes to using a confession of another Confederate as it relates to confrontation clause concerns? Let's get started with this. Petitioner Adam Samia, along with Joseph Hunter and Carl Siltwell, were arrested by the DEA and charged with murder for hire of Catherine Lee. Okay, please don't commit the murder for hire. Murder for hire is bad. Conspiracy for murder for hire is illegal. Please don't do the conspiracies for the murder for hire. It is a bad thing to do. The government tried all three defendants jointly in the Southern District of New York. Prior to trial, the government moved to admit Stillwell's post-arrest confession, in which he admitted that he had been in the van in which Lee was killed, but claimed that Samia had shot Lee. So yes, one of them confessed. One of them said, yes, it was me. I was there, but I didn't shoot the guy. Someone else shot the guy. Since Stillwell will not be testifying on his own behalf, and the full confession implicates Samia, the government proposed the confession be introduced through the testimony of a DEA agent who would testify to the content of the confession in a way that eliminated Samia's name while avoiding any obvious indications of redaction. The district court granted the government's motion with additional alterations to conform to its understanding. So what we'd like to do is one of the guys testified. Well, one of the guys confessed. Okay, he was brought before the government. He was brought to the jail, and they said, "You have the right to remain silent." And he said, "No, I wouldn't like the right to remain silent. The right to remain silent is bad. I'd like to talk to you about all the things." Okay, what would you like to tell us? Yeah, I was totally there. I totally did it. But it wasn't me who shot the guy. I was there, though. It was me. I did the things. It was me. I was responsible. Okay, so now it's trial time. So guy who so earlier was so willing to talk to the police seems to be somewhat unwilling to take the stand in his own defense. So this guy over here, not thrilled about taking the stand and telling the jury what he earlier told the police so willingly. All right, so the police would like to use his confession against him, as one does. But remind you that all of them are being held jointly. They're being tried jointly, right? So this deals with the confrontation clause because this guy confessed to himself, fine, but also implicates his co-defendants who are sitting right next to him, right? Now, we can't force him to the stand because, the right against remaining silent, and this guy apparently would like to remain silent now. So this other co-defendant can't confront his co-defendant because right to remain silent, and this confession is being used. So how do we deal with this problem? The district court says, okay, here's what we're going to do. Okay, DEA, you can bring in this confession against the guy, but you have to eliminate from your testimony any mention of the other people's names, and you have to eliminate from your testimony other things that would identify them. So yes, you can bring in their testimony. Yes, you can say he confessed. Yes, you can say he confessed to being in a conspiracy, but leave out the names. Leave out the names. We don't know who they're in a conspiracy with as he sits at the defense table with the other people. Could be anybody, right? And we'll trust the jury draws the right conclusion. Okay. So at trial, the government's theory of the case was that Hunter had hired Samia and Stillwell to pose as real estate buyers and visit properties with Lee, and that Samia, Stillwell, and Lee were in a van driven by Stillwell when Samia shot Lee. So they want to kill this woman. She's a real estate agent. So how do we get her? We'll pose as buyers. We'll pose as buyers for the real estate. The three of us will pose as buyers, and we'll convince her to please enter our van so we can discuss privately, this deal we want to do, because the van will be a nice place where it'll be secluded from others. And then, we shoot you. And then that's the murder for hire. So that's what we did, apparently. Okay. As the government's case in chief, the DEA testified that Stillwell had confessed to a time when the other person he was with pulled the trigger on the woman in the van that he and Stillwell was driving. So who is this mysterious other person, right? There are three of them on trial. Okay, there are three of them on trial. He's one of them. There's one of them that's driving the vehicle, and a mysterious unnamed third person. Also, there are three people at the defense table. Him, the other guy, and a third guy. Who is this mysterious third person? We have no idea who it could possibly be. It could be anybody. We know that he was in the van. We know that the other guy is in the driver's seat. Who's the mysterious third person who pulled the trigger? Could be literally anybody. We didn't mention their name. Okie dokie. Other portions of the testimony recounting the confession use the other person descriptor to refer to somebody, just anybody, whom Stillwell had traveled with and lived with and carried a particular firearm. Both before the agent's testimony and again prior to deliberations, district court instructed the jury the agent's testimony about Stillwell's confession was admissible only as to Stillwell. Hey, jury, this confession that Stillwell gave, only for him, okay? Don't consider the confession that Stillwell gave against any other person, particularly unnamed people who may or may not in any way be related to people sitting at the defense table, okay? Don't consider it for any other purpose, just this purpose, okay? All right. And should not be considered against Samia or Hunter. Please don't consider the confession that clearly implicates some random person against anyone who may or may not be sitting at the defense table. Samia and his co-defendants were convicted of all counts. They did the murder for hire. On appeal, Samia argues that the omission of the confession was error because other evidence and statements at trial enabled the jury to immediately infer the other person described that the confession was himself. Well, there is some suggestion that a reasonable person might draw that inference, right? There are three people who were involved in this murder, according to the confession. We named two of them, okay? We named two of them. Those two people are currently sitting at the defense table, okay? There's also an unnamed third person. Could be literally anyone. Also, there's a third person sitting at the defense table. I wonder if the unnamed third person and the person sitting at the defense table might at all be the same person. The Second Circuit, pointing to the established practice of replacing a defendant's name with a neutral noun or pronoun in a non-testifying codefendant confession, held this is not a problem. The Supreme Court says not a problem. This is fine. This is totally fine. Not a problem. Yeah, this sounds totally fine. The confession was only admissible against the one guy, don't you know? And we never named the third person, even though there's only three people sitting at the defense table, and we named two of them. So we named two of them. We didn't tell you who the third person was, but there are three people. But that's totally not. That's just an inference the jury could draw. They don't have to draw the conclusion. It could be the third person sitting conveniently at the defense table. Could be literally anybody. Okay, so no problem. This is totally fine. Stillwell's formal Mirandized confession to authorities is testimonial. Yeah, so they told him about his right to remain silent, and he's like, I don't want to remain silent. I'd like to tell you all about it. And for some reason that's unclear, he doesn't want to tell the jury about it. I don't know why. He was so thrilled to tell the police all about it. He was so happy to tell them. They told him he had the right to remain silent. He's like, I don't want to remain silent. I want to tell you all the things. But for some reason, he doesn't want to take the stand and tell the jury about all the things. I don't get it. He was so eager to talk to the police earlier. Why doesn't he want to talk to the jury? I don't know. But he wants to enforce his right to remain silent now. Okay, so we can use this against him. So we can use it against him because the witness is unavailable. because, he has the right to remain silent, which you like to exercise now very much. And ordinarily, a witness whose testimony is introduced at a joint trial is not considered to be a witness against the defendant if the jury is instructed to consider that testimony only against the defendant. So yes, his confession can only be used against him. So we told the jury all about it. We didn't mention the third person by name at all. And we told the jury, hey, this confession is only to be used against the one person, man. It's only his confession. So don't use it against any other people that may or may not be sitting at the defense table. Long-standing practice permits the non-testifying co-defendant confession to be admitted at the joint trial, as long as we, tell you not to consider it. This practice is identified in early treatises and many states with similar constitutional rights. Notably, none of the treatises or cases suggest a confession naming a co-defendant must in all cases be altered to refer to another person. Thus, while it's unclear any alteration of the confession is necessary, so we're not even saying, for the record, the Constitution even requires that much. We're not even saying, for the record, that mentioning the other guy's name would have been improper. We've only said that you have to tell the jury they can only consider it on the one person. We never said you had to substitute a placeholder name. So, we're not even saying that much is required. Historical practice suggests altering a non-testifying co-defendant's confession not to name the defendant, coupled with a limiting instruction, is enough. So are you required to do that much? We're not going to tell you. But what you did is enough. So are you required to alter the name? Maybe, maybe not. But you did, and that's enough. So, some future prosecutor out there is going to try to get the name in, and we'll have a future case about it. But this is another problem for another day. The historical practice is in accord with the law's broader assessment that jurors will attend closely the particular language of limiting instructions and strive to understand and make sense of them. We believe jurors are smart jurors. We believe jurors follow the instructions of the court. We believe that jurors have sworn an oath to obey the instructions of the court, and the court told them. They told them you can only use this confession against the one person, no one else who may or may not be sitting against the defense table. There's a conspiracy that this guy says involved 3 people. We have told you the names of 2 of them. Those 2 people are sitting at the defense table. Also, there's an unnamed third person. Also, there's a third person at the defense table who may or may not be related. But we explicitly told you, jury, only use it against the one guy, no one else. And that's enough because jury is smart jury and will totally obey our instructions. The legal fictions are real. To disregard or make unnecessary exceptions to the principle will make inroads to the entire complex code of criminal evidentiary law and threaten other large areas of jurisprudence. The courts, in a case called Boutin, recognized a narrower exception to the presumption jurors follow instructions, holding the defendant is deprived of the Sixth Amendment right of confrontation when the facially incriminating confession of a non-testifying co-defendant is introduced, even with a proper instruction. So, yes, we have said before that if it's facially incriminating, that is the problem. In that case, the prosecution introduced a confession by a co-defendant that implicated the guy by name. So, yeah, the court held that the confession's introduction substantially threatened the right to confrontation, reasoning there's some context in which the risk the jury will not or cannot follow the instructions is so great and the consequences of failure so vital that the practice and human limitation of the jury system cannot be ignored. So while the original treatises, while the old treatises, and the Supreme Court is throwing shade on itself, incidentally, right now. The Supreme Court throwing shade on itself and saying, okay, in the original old treatises, we didn't require the substitution of name thing, but a prior Supreme Court, a prior Supreme Court la-di-da said, you can't use the guy's name. That is too much, okay? You can't say it was me and Smith when Smith is sitting at the defense table, okay? You can't say me and Smith entered into a conspiracy, but you can say me and some other person unnamed was involved in a conspiracy while Smith's sitting at the table, and that's totally different. So no names, and the jury will obey that instruction. So if we said me and Smith we think the jury might be too prejudiced. But if we just say it was some guy, any guy, may or may not be related to anyone at the defense table, that's totally fine. Okie dokie. The court in Gray later qualified this by holding that certain obvious redacted convictions might be directly accusatory, even if they did not specifically use the name. So, okay, you didn't use their name. That's great. But there were other details that may have clearly implicated the guy, right? So, yeah, it's like maybe the defendant mentioned the guy's name. It's like, okay, can you describe your co-defendant? I sure can. My co-defendant is a white male. He's age 42. He has thinning red hair. He sometimes has a scraggly beard. He's overweight. He sometimes wears the cowboy hat. Has piercing blue to hazel eyes. And is an accomplished lawyer. Right? So that is my co-defendant. And so yeah, we strike out the name, and it could be anyone fitting this description, who just happens to be, someone meeting that description who's sitting at the stand. It's like, yeah, that might be a little bit too specific. So yeah, just deleting their name may not be enough. You might have to delete a little bit more. The court in the prior law concluded that when redacted confession is simply places name with an obvious blank space, such as word is deleted, or symbol, or similarly obvious indication, the evidence is so close that, not enough. So it's not enough to merely delete the name. You might have to go a little bit more to get rid of some other details that might somewhat suggest who it is. Those details are too much. It could be anyone. It has to be clear. It has to be clear. We're going to alter the confession. We're going to alter the confession so that it could be just anybody who may or may not be sitting at the defense table, right? So no names, no specific details. We'll edit it. We'll transform the confession to other words to avoid this problem. And it could be anyone involved in a conspiracy who may or may not be sitting at the defense table. Okay. The court precedents in this area distinguish between confessions that directly implicate the defendant and those that do so indirectly. So indirectly will be fine. Accordingly, none of our case law provides a license to fly-spec trial transcripts in search of evidence that could give rise to collateral inferences. So yes, you are now digging through the transcript, looking for any hints at all that could be alluding to the guy, but we're not going to let you do that. We're not going to let you look for little specks in the wind. So yes, there might be little tiny clues that it could be someone related to defense table, spattered throughout. There could be some clues, but just because there's perhaps some breadcrumbs is not enough. So the occasional breadcrumb is not enough. The admission of the confession, accompanied by a limiting instruction, did not run afoul of the court precedent. The confession was redacted to avoid obviously naming the person, and it was not obviously redacted in a manner that would show that it was redacted. So close enough for us. Explaining the prior law in a way that Samia proposes would be inconsistent with long-standing practice and this court precedent, which would work unnecessary and imprudent changes in law and would require federal and state trial courts to conduct extensive pretrial hearings because it would be impractical to fully police jury inferences. The likely practical consequence of extending the case law here would be manifest severance whenever the prosecution wishes to introduce the confession of a non-testifying co-defendant. So if we went this far, we would have to sever all those trials, and that would be really inconvenient. We'd really like to try you all at one time, save us money and save us time and save us energy. So, no, we're not going to sever all the trials. You get to sit next there. You get to sit next to Garrett with me and other party unnamed. And the jury can just draw any potential conclusion. And, we're not going to police the jury's conclusion and inferences because they've been instructed. They've been instructed, remind you, to only consider it against the one guy, not anyone else who may or may not be at defense table. So this is too much. We're not going to sever all the trials now. The proposal is not compelled by the Confrontation Clause and ignores the vital role joint trials play in criminal justice and the fact that confessions are essential to compelling evidence. Affirmed in Thomas Delivers the Opinion of the Court, in which Roberts, Alito, Gorsuch, and Kavanaugh and Barrett join. Barrett files an opinion concurring. Kagan files a dissent in which Sotomayor Jackson dissents 6-3. Thus, that brings the end of the opinion from the United States Supreme Court, in which we continue to learn that conspiracies are bad and conspiracies don't pay. If you're involved in a conspiracy, if any of your co-conspirators, testify at all and provide evidence to the police, that evidence can and will be admissible at trial. But don't worry, it's only admissible against them, and we're going to redact all their names, and it won't be clear that we did it in redactions, right? It will just be if they were in a conspiracy with somebody, anybody. It could be literally anyone of any description. Also, by the way, have you looked over at defense table? There's some people sitting over there. Also, could be literally anybody at all. So again, not a good idea to join a conspiracy, because any of your co-conspirators testify or provide evidence to the police, well, that can and will be used against them. Will not be used against you. It won't be used against you. And we'll make absolutely clear to the jury it's not to be used against you in any way. So I feel reassured. Don't commit conspiracies. And that, for the end of the moment, brings us to the end of the discussion of this story.